What's up, everybody? Sorry I'm late. I don't like to come late to these parties, but I'm on my own tonight. And we were at our first trunk or treat of the season. And it went longer than expected, but we're here. We're ready to rock and roll. I know we had a poll started, and there's already 2,300 votes on that poll. And it is, if you were on the jury right now, which way do you lean? It is 98% leaning towards guilty, only 2% leaning guilty. We're talking about Darrell Brooks. We're talking about the man, the myth, and the anti-legend, and what I felt was the worst day conduct-wise for Darrell Brooks, and also the worst day for the judge. And I don't like disparaging judges or lawyers on this channel. I don't like to do it. I really don't do it, and I'm not going to disparage this judge today, but I am going to disagree with how she's handled certain things in the courtroom. And to me, this was a culmination of how she's handled the entirety of this trial. And he is not only going to take what she gives him, he's going to try to take way more. And that's exactly what he did. So thank you for joining me. I know we're a day late, but it's a Saturday night special, which is really fun. And I know a lot of you are new from this Darrell Brooks trial. And if you're new here and you haven't subscribed yet, hit that subscribe button, because we do a lot of different things on this channel. We break down cases in the news like this one. We also go through just some legal topics, letting you know what your rights are, making sure you're not waiving rights. And we also just talk about the law, talk about law school. We hit all sorts of things on here. We'll talk a little golf tonight. I already see some golf questions in the chat. And one of the main things that I love to do and that you all seem to like is we do a lot of question and answer. So I've got a lot of clips that we're going to talk about from Friday. And in between those clips, we'll answer a lot of questions. So feel free to get your questions in. I get to absolutely as many as I can. Sometimes I don't hit them all, but usually we're limited on time. I don't think I'm going to limit it to an hour. We may have interruptions because bedtime is kind of happening right now. I've done all my duties with bedtime, but they are not quite down just yet. So we will see how that goes. And if we have any interruptions, we'll deal with them, right? That's life. Yeah, hit that like button. Thank you, Rachel. Subscribe, do all the things. But let's get to it. Day 12 starts with a big argument between the judge and Darrell Brooks. And she tells him the jury's coming in, so he's got to stop. He keeps fighting because he wants to talk about something. And what does she do? She sends the jury back out so Darrell Brooks can argue his point, fight about it. Hello, Nurse M, and welcome. And she just lets him win that argument. And he then makes a big deal about not calling his mom to dispute what the officer said, and how the officer didn't actually call his mom and he knows it and it's fact and all of that. They argue. She warns him. She gives him one warning, the last warning, one more warning. And she just lets him continue to be belligerent in the courtroom. Then he calls his first witness, who basically, because when he calls a witness, right, sometimes it's hard to figure out. Love you. Good night. Sometimes it's hard to figure out what he's trying to get out of this witness. And so I've tried to pull what I thought was the best point for Darrell Brooks for each witness, right? And this one, it was basically that he honked his horn. He was speeding. Oops. Didn't know the witness was going to say that, I guess. But he didn't hit this witness or his daughter. That was about as good as it got for this witness for Darrell Brooks. The second witness was a detective that was called to the scene. He did talk to Erica Patterson, who was Darrell Brooks' estranged girlfriend. And he said, well, what do you mean by estranged? And the officer looks at the judge and he's like, well, I don't think I should answer that. Yeah, because that's once again getting into other bad acts. And then he asks, well, what happened? What did you respond to? And the officer explains the horrific account of the fight between Darrell Brooks and Erica. Now, what came good for Darrell Brooks on this witness was Erica was less than truthful about some of the statements that she may have made, basically indicating to me that she was scared of Darrell Brooks doing something after she told the officer what had happened. And the officer even said, basically, because she was scared of you. That's why this happened. So then we get to some more argument about witnesses. And I want to play it because some of the stuff Darrell Brooks says is just so rich. Because it's like, you are saying this? Multiple times it was like pot calling the kettle black moments. And we're going to get to our first one here. And as we watch some of these clips, we'll put the new members up on the screen. Join if you want, but you don't have to. Like and subscribe, you got to do that. So let's get to this first clip here and listen to what Darrell Brooks has to say that we should all listen to and learn from. Oh, I think I have it on 2 times speed still. Let's drop it down.
That's not efficient. That's not effective. And it's not courteous to them. People have families, people have jobs and other responsibilities. And we're trying to be mindful of all of that as well while having the state assist you in getting these people here. So I'm advising you that if you don't call her right now, you will forfeit your right to call her.
Is that lawful law?
Sir, I believe I have the authority to do that. She's here.
Is that lawful law? Just in case anybody's wondering, and if it is confusing, that's not a real thing to ask if it's lawful law.
She's ready to go.
I'm just
She's
asking
your
the question.
witness.
I'm just asking the question. Is that lawful law?
I have the authority under 906.11 and other rules and the inherent authority of this court to control the order and mode of interrogation
Your Honor,
of
why
witnesses.
is it always so hard to just say yes or no? Is
Yes,
it lawful
I have
law?
the authority, sir.
I'm not disputing.
Your Honor, why is it always so hard to say yes or no? I seem to recall somebody else having trouble saying yes or no to very simple questions, and it's not Your Honor.
Disputing that.
You just
I'm not disputing. No, I asked the question. Is it lawful law?
Sir, I've told you what I believe my authority is. Okay,
You
if
told
you don't
me
want
what
to
you-
recognize it, that's
you told
fine.
me
You
your
want to object
authority.
and note it, that's
Tell
fine.
me your
Your
authority.
objection
I'm
is
not
noted on the
debating
record.
your authority. I'm not.
So I will address one other issue with you because you said you had an issue regarding the last witness, which is fine. We can address that quickly. And then I'm going to have the jury brought in and that will be your opportunity to call
That's a
Ms.
misdirect.
Patterson.
That's a misdirect. What issue did I say I had with the
You
last?
said you wanted to
I
raise
said
By the way, when he says that's a misdirect, I think he means she's trying to change the subject, but sometimes it's hard. But I think he's saying that was she's trying to change the subject on him.
an issue with
what I
Detective
said
Booth's
was I
testimony.
might have more questions for that witness. I didn't say it was an issue.
Oh, I didn't hear that, sir. You had your opportunity to ask the witness questions. He's been released.
Okay, so let's stop it right there. Everybody heard that. Sir, you've had your opportunity to ask this witness questions, and he's been released. She says that, as a matter of fact, as she can because she's the judge. Now, if she's going to say that, she did not need to say that. She could have said, if you want to recall him, fine, recall him, we'll keep him under subpoena. But she said that. And once you say it as a judge, you've got to stick to it. Because if you don't, then it's going to get walked all over throughout the entire trial. And let's hear how quickly this turns.
Your Honor, if I mumble something under my breath, somehow that's audible. But when I talk clearly, somehow
I may
nobody
have
hears
missed
me.
it, but I heard what I interpreted was when you said I may have an issue with this witness. I didn't understand. I guess I didn't take that as you were going to reserve your right to recall him. So are you telling me you'd like to reserve your right to recall Detective Booth?
Yes.
All right, then that will be noted and we'll keep him under the subpoena.
And just like that, Darrell Brooks gets his way once again. And there are some things that are really important, and you do have to protect his rights. We've talked about this over and over again, but just be a little slower to try to lay down the law if you're not actually going to lay it down and you're not actually going to hold him to it. That's the only thing I would say, because we're going to see other problems with that. And we get to our first big explosion a little later in the day. Let's listen to it together.
So the person, if we know this, then we can be prepared. So we'll already be ready.
Mr. Brooks,
That was
I
the
asked her
whole aim of that.
yesterday, and I would have had her come in later. You didn't want to answer that question.
There was no
And
question. There was no question to answer.
That's
I
not true.
did what you asked me to do, Your Honor. You
No, you
said
didn't.
yes, you did. You did. You asked me to give them my witness
Mr.
list.
Brooks,
I gave them my witness list. It's not my fault. It's not my fault they weren't going to be prepared to do their
Here's the deal.
to do
The
their
jury's
cross.
coming out, and I'm going to stand my ground on this.
I'm going to
It
stand my
is-
ground too, but I'm
if
not
you
going to
don't
be
call her-
disrespectful or disruptive.
If you
I'm just
don't
stating I
call
wanted to be
her
fair.
when the jury comes back out, I'm releasing her from the subpoena.
You can't do that.
For your
Where's
lack
the
of
lawful law?
cooperation.
Where's the lawful law? I have the right to
You
witness
have to
this,
cooperate with this process.
but I also
sir.
have the Sixth Amendment
Well,
right.
We have a witness available for you to call. I can require
It's
you
not
to
the
call
witness
her
that
right
should have
now.
been called at this time, Your Honor.
It is based on the list that you provided and
That didn't
in
have a
order.
time. That didn't have a time or
I'm not going to play
order.
this game with you.
It's
sir.
not no game. That's
It
what you
was-
don't
it
seem
is
to
a game to
understand.
you. I believe that fully.
I don't care what you believe fully.
All right.
It's not a game.
We.
I don't take this as a game. That's what nobody. That's what nobody. You don't got to explain nothing to me.
Do you want?
That's what you don't understand.
It seems like she's got to explain a lot to him. Once again, like he says these things and he's so confident in the way that he says some of this stuff. And it's like, you've been asking her to explain stuff to you every second of every day.
Think that this is a whole game to me. This is not a game to me, Your Honor. Nothing about this is a joke. That's what y'all don't understand. And it's unfair. It's unfair and it's disrespectful to me that you think I would come in here purposely and treat this like a joke or a game.
I never said it was a
What
joke.
type of statement is that?
Mr.
Your life is not on the line. Mine is. And you think that I think this is funny?
I don't think it's funny whatsoever.
So
And
I
understand.
think, Your Honor, with all due respect, I think you
So
should show
we're
some
going to take a
respect.
5-minute break, and when we come back, the jury's coming out, and you need to call your next witness. Thank you. We are in
No,
recess.
you're not rushing me to judgment. I don't care what you're talking about.
Demanding that Your Honor show him some respect. All glory and honor to him is what Mr. Brooks wants. It's tough to watch this. Like it really is tough to watch this. It's tough to see a sitting judge get treated like this and continue to be too passive, in my opinion, as to how she handles some of this. And I get tiptoeing around his constitutional rights and making sure we preserve everything for appeal. And I talked about that a lot at the beginning of this case and to expect some of this. But he is taking it way too far. And I do think that he is taking some cues from this judge and how she's handling the arguments and the fights, and that eventually she is giving in to some of his tirades, which I think is very problematic for, even just the rest of this trial. And yeah, like Ackles is saying, it feels like she's lost a bit of control, and it may be hard to get that back. And I think that's something that, we're going to find out as the trial continues. We had another fight about subject matter jurisdiction and how he's not ready to call Erica Patterson and how the judge was trying to force him to call Erica Patterson out of turn. And this is why he didn't want to tell them when he's going to call it. And, after this big fight, she basically says, if you're not going to call Erica Patterson, then you're not going to call. If you don't call her now, then you're not going to get to call her. And he asked if that was lawful law, as Carla Miller said, an exhibit. But he ends up calling her. And yes, Mo, how dare you put my witnesses in order? Then what's the order? How dare you ask the order? Yes. Just have them sit out there for days and days and days so I can harass them more. And I think it became clear today that at least part of what he's doing is harassing these people. And the court has tried to prevent that. But if you're going to have somebody acting like him, you can only do so much. And when Erica Patterson's on the stand, the state at one point, this was interesting. The state at one point objected to, he was asking repetitive questions or something they had already hit in direct before. And they object. And then he says, I object to that objection. And then he starts making an argument. And he sounds so confident that when you listen to make this argument that just literally makes no sense, you sit there and you're just like, this is why this is happening. He either thinks he's doing a good job. He thinks that he may win this case. He thinks that he's looking like a big shot, and he's just going to keep riding this wave as long as he can. Yes, Sad Tiger, his legs are cuffed to the table, and he's got a shock collar on his legs. So he thinks it's going well for him, I think, at times. And then he starts asking Erica Patterson about an alleged abuse, I believe, that happened on the 20th, the day before the 21st. And like that's probably not supposed to come in as other bad acts since the state actually dropped those charges. But he asks her and he's like, oh, were you injured? Were you injured? And she's like, I didn't have any visible marks. Yes, Emery. It feels like he knows he can get away with it at this point. And they act like because she had no visible marks, let's talk about it in front of the jury. You must have been lying. Were you injured? She's like, you hit me. He's like, did it leave marks? So you weren't injured, were you? It's gross. It's gross to have a dude do that. And those were the kinds of questions and lines of questioning he had for her. And it was horrible. Like, I just thought his entire, and then where he was trying to go, we'll get there, of course, because that's going to be a big part of it. Mara Chandler said, I wish he would have had the judge that they had in the Rittenhouse trial. I don't think he would have gotten away with any of this. Absolutely not. I think that judge would have yelled at him from the bench. But he didn't. He has this judge. And he starts down the line of questioning of, you know, the child we have together, do you still keep in touch with that child? Trying to make her seem like a bad mom. Saying none of her children live with her, not just the child they have together. And he tries to testify about her sending him some letter with pictures in it that only she could send the letters. And he testifies in his questions, right? He's testifying that she sent in the letters, even though it's facts, not evidence, even though it's not actually true, as we find out later. We find out a lot about this later. But as we sit right now, he just wants the jury to think that something's going on that's not actually going on. And I'm going to answer some questions before we get to this next part of the video, which is, to me, some of the most shocking video that we're going to get through the entire night. So I'm starting back kind of early on. So if you think your question's not getting read, it probably will. But it'll take some time to get there, obviously, because I'm recapping, explaining, reacting to parts of the trial, and then, of course, answering questions. So thank you for sending them in. Michelle, does he have the constitutional right to a public defender for an appeal? How does that work? Yes. An appellate lawyer will be provided for him. Heather Forder, the mom and her 4 kids, we're getting there, Heather. It is going to be brutal when we get there. MVD. First, apologize for repeated questions the other day. Don't ever apologize. I try to get to as many as I can, as you know. Super chats show a loading bar, so I thought they disappeared. Question, do appeal courts have to have kid gloves on the way this judge does? Absolutely not. The appellate court, it's very hard to win criminal appeals. They're going to read this. They're going to see what a jerk he was. And unless something is blatantly reversible error and this judge just totally stuck her foot in it, which I don't think she's done at all, at this point, that's the best thing you can say about this judge is she's not creating any appellate issues. No, they're not going to have kid gloves on with him. But he's not going to like be in front of them, you know? It's just paperwork, basically. Cynthia Snodgrass, you were right. The judge didn't let DB go in on Erica. I just hope at sentencing the judge gives a piece of her mind. He's way out of control yesterday. Oh, I think she will. I hope she does. Mo continued to tell me that 2% not guilty was an accident. We're going to throw up a couple other polls tonight. So make sure you keep an eye on those and answer them. And John will send me some screenshots of what those percentages look like. We're going to talk about intent. And then I talked about one other one. I can't remember what it was. Paula, in closing arguments, do you think the prosecution will discuss subject matter jurisdiction and the other soft sit BS for the jury? I don't think they will. I think the judge will literally instruct the jury that they are not to consider that. Azam, what's up? Peter, how was your golf tournament? It was awesome. I played 2 rounds. It's like a 2v2, 2-man scramble type of thing. And we have 2 teams, kind of Ryder Cup style. Lost my first match, won my second match, but our team overall won. So it was very fun. 149K subs. You may hit 150K during the live stream. Put the real-time sub counter up. I don't know how to do the real-time sub counter. I don't know if John does, if you want to look that up. But that would be awesome if we could hit 150 during this live. And I think it's possible because I'm going to do a little overtime with you guys tonight. We're not going to cut it at an hour like we usually do. So get excited. Tori, I felt like the judge should have put her foot down. The prosecution and the jury has rights to, and she lets Brooks accuse the prosecution of horrible things. Shouldn't that be dealt with? She's trying to deal with it as best she can, but I agree. I definitely think she should be a little stronger. And we'll go in a little bit more on this judge a little later in the show today. Dana Nori, I noticed several of the witnesses either forgot what they told the police or what they said was different from what the police report was. Is that typical? And DB not read it correctly? Glad you're back. Glad to be back. So that's what he's annoyed with. And that happens sometimes when people change their stories. And the point, what you do is, well, this is what you told police, right? And this is what you're saying now. Okay. Then you leave it to the jury. When were they more accurately thinking about this? The night it happened or a year and a half later? When they were talking to law enforcement trying to help, or now when they're trying to help the prosecution? You can make those kind of arguments in closing. That's perfectly fine for him to do. And I think he did bring out some inaccuracies about the 3 black men getting out of the car, or, he was driving here or not driving there. He was driving slow. He brought out some inaccuracies, and I think that's fine. And I think that's something a criminal defense lawyer would do. But he just does such a horrible job of going around it the wrong ways. And then he steps in it. Almost every witness, he stepped in something. Stephanie Stewart, it's time for the judge to boot this guy permanently to the second courtroom he's discussing. I would have done it a long time ago. Melanie Casio, I can't help but wonder how differently this would go in different states. I don't think it'd be like this in Massachusetts from the judge or the witness. It would not be in Florida either. Little K, DB asked ex-girlfriend if she called him Darrell Brooks. She responded, no. Could the prosecution have asked what she called him? I missed that part. I must have missed that part, but that's interesting. Julie, Peter, the prosecutor keeps talking about what he's been saying on his phone calls about how he's going to do everything he can to delay the trial. Can they play phone calls in court to get that on the record? No, they can't play those phone calls. Well, I mean, I guess they probably could, or they could submit them as part of the records. I haven't heard her say he's trying to delay the trial on purpose. They have referenced like he talked to his mom, or he talked to this person, or they know those letters aren't from him. I've heard them reference that. I haven't heard them reference that he's delaying on purpose. They can play those calls to impeach him if he takes a stand, for sure, and they cross-examine him. That is absolutely something that can happen. I don't think they can just play them generally. They definitely can't just like play them in the trial. But they may be part of the appellate record if the prosecution wants to put that in as part of the appellate record. But I'm not really sure how they would get that in. Ginger Snap Girl, the next time he wants to question Wisconsin, they need to bring in a dairy cow, a wheel of cheese, and a Packer fan. Wisconsin has entered the building. Tori, I feel like the judge has allowed the prosecution to be prejudiced by Brooks's attack on their conduct. She should have done something better. I'm sorry. She was way out of line. I felt I had to go there. Golden Queen Diva, can DB claim crime of passion or diminished capacity as a defense? I don't think he's going to go with diminished capacity, but he's definitely going with accident, that it wasn't intentional. And that's one of the questions I have for you guys. Do you think the state has proven intent to this point? He's definitely going to be guilty of a crime, but will it be an intentional homicide? How is the direct handled, BC? You have a pro se defendant testifying at trial. So we get this question a lot. He will just take the stand, most likely. And I think he could probably have somebody like a standby counsel come ask him questions if he wanted to. I know the judge has said no to standby counsel, but most likely he's going to take the stand, just give a narrative, tell what he thinks happened. The state gets to cross-examine him. And after, for his redirect, he will just get to clarify anything he wants to clarify from cross-examination, or anything he didn't get out that he wanted to get out. Missy Michelbel. Question, why is the judge allowing him to continue to behave the way he is with any other attorney? Is he allowed to get away with this in any courtroom? I'm trying to wrap my head around this. Absolutely not. She's letting him get away with it because he's a pro se defendant. He's a sovereign citizen. She doesn't want to give any chance that they could appeal this case or win on appeal. So she's trying to handle him with kid gloves as much as she possibly can. All right, let's get to the next clip here where we talk about why it's so horrible that he's trying to call Erica Patterson a horrible mother, and how he argues with the judge all the time. She tells him over and over again, we need this letter as proof that she sent you the pictures that you're saying she sent you. Later, we find out what's in those pictures, so I'll save it for then. And, he keeps arguing about somebody moved his papers around, and the judge gets annoyed at him. But once again, the judge even says it in her own words, I'm going to indulge you, which is not something we ever want to hear in this case. And let's see what exactly the judge indulges him on.
And you keep interrupting me repeatedly today. I have shown an abundance of patience this morning. I've warned you repeatedly about being removed from the courtroom. And then every time I try to get into it, you, meaning an explanation and make a record, you interrupt, you attempt to divert everyone from what is being done this very second.
I didn't attempt to do anything.
Yes, you do it repeatedly, sir.
Whatever.
So you're doing it once again.
Whatever. Just make your record.
The document that Mr. Brooks wanted to show Detective Guth and this witness was a letter sent from the state of Wisconsin to the court regarding count 77. The state sought to dismiss that count, and they have prosecutorial discretion. And I granted the request that the charge be dismissed.
Why was the charge dismissed?
And that's, I can't answer. It was dismissed because the request was made, sir. They don't need a reason. There's an abundance of case law about prosecutorial discretion. And they chose not to pursue that. My guess is maybe to simplify things and to keep this tidy. I don't know. You know what? I'll indulge you. Attorney Opper, would you like to provide a basis for why the state sought dismissal of that charge prior to the start?
And this was one of the charges of battery on Erica Patterson. But here's the exact point. Like, why indulge him? Why give him this answer? He is not entitled to why they dropped those charges. He's not entitled to that. It's so frustrating. Here for the truth. Who do you mean by her? The judge? Sure, she can seek counsel anytime.
The start of this trial.
Yes, Your Honor, because as Ms. Patterson just testified a short while ago, she did not have any visible marks or injuries from that event. And we did have the photographs of her injuries. We did not want to confuse the record as to whether or not there was a battery that occurred on November 20th.
Your Honor, I object to that. What does the letter read?
You have the letter. You showed it to me, sir.
And I've been trying to find it ever since I came back in here. Now all of a sudden I can't.
And now you're impugning, though, like somehow you're impugning the integrity of this.
So he says, oh, I had the letter. I have it right here. I have it. Later, we find out that the bailiffs multiple times offered to take him back to his cell to get it, and he didn't want to get it, and we'll find out why later.
Court, the bailiffs of the state, you're accusing, frankly, everyone of moving your papers.
Did I point the finger at anyone? Did I say anyone did anything?
Not directly, but indirectly you did.
So how can you make the assumption that I'm saying?
Can I please make the record without being interrupted?
Yes, you may. I apologize.
I appreciate that. Thank you. But you made repeated comments, sir, about I can't find my documents. I don't know what happened. Things of that nature. When you came back out, you took multiple minutes before you even asked your first question of Ms. Patterson. And if I need to, I'll have a bailiff put on the record that no one touched your table.
Your Honor, did I?
Like, that's a joke. You're going to have a bailiff put it on the record that no one touched the table? This is unnecessary stuff. Like, I would be like, dude, nobody touched your table. Move on. We got cameras in the courtroom. Nobody touched your table. All Doogie, yes. Let's get a poll going on, will he testify, yes or no? And then we're going to get to something that really shook Darrell Brooks today. And again, lets us know a little bit more about who we're dealing with and why there are some of the issues that there are. And the judge, or the state attorney, again, I told you, I like that dude, state attorney. He's got some stones, and he's like, you know what? Let's get to it. Darrell Brooks wants the truth, and everybody wants to hear the truth. Let's hear the truth, and we'll hear how Darrell Brooks, again, he can say I didn't threaten you, or I didn't do this, or I didn't do that. It's a very threatening tone, and this guy does not seem shaken at all, this state attorney. But let's listen to this interaction that a lot of you send me this clip. And, I mean, it's wild. It's getting wild in there, for sure.
Everybody seems to hear it. Everybody seems to hear
in
it.
In a quiet courtroom, yes, we can hear it very clearly.
Everybody assumes that it has to be disparaging.
Once again, you're doing this tactic.
Because
it's
not a tactic. It's
what
facts.
we're talking
It's
about
facts.
To some other reason.
It's facts. Because I find it hard to believe that
I'm going to
all
let
of
the
a sudden
state,
nobody hears what I say.
I'm going to let the state make a record of why they believe it's objectionable, because I haven't let them do that. I've given you multiple opportunities to tell me why.
Lawful law is not a thing. He's just saying, like, is it legal, I guess is what he's saying, or is there some law to back it up? So don't get confused. It's literally a nothingism.
I didn't get these pictures from nobody else. Why was somebody
The record will
else
reflect you have two pictures that you believe were from this witness.
that I know is from?
No, that you believe.
That I know.
All right, I'll ask the state their position on all of this.
My position, Your Honor, is that these pictures, first of all, should not be admissible. One, because of a discovery violation. We've never seen them before. Two, because we have.
And discovery violation is we turn everything over in discovery. They turn everything over to us. If we don't turn something over to them in discovery, we cannot use it at trial. There's no aha, gotcha moments, smoking guns that they don't know about. That's not really how it works. Now, once in a while, if something becomes admissible that didn't before, or we didn't know about it until trial started, there are exceptional circumstances. That's not what this is. If you don't turn it over, you can't use it. But there's more.
I believe that he did not get them from Erica Patterson. He is on a jail phone call talking to his mother, Dawn Woods, about Dawn Woods sending these photographs to him. Now,
that's a lie. I object
Let
to
the
that.
state make their argument without interruptions.
That's a lie, though.
three, I believe that these photographs are designed to make a suggestion to the jury that Erica Patterson is a bad mom. I think that is what the defendant is trying to do. And if we're going to go down that road, then we would be forced to counter that claim. First of all, it doesn't make her an incredible witness, if it's even true. And second of all, if we go down that road, we would be forced to counter that claim by pointing out that not only does the defendant not live with the child in question, he doesn't live with any of the other children that he has. He impregnated Erica Patterson when she was a minor in Nevada, and for doing so, he was convicted of statutory sexual seduction, pled guilty in March of 2007 to that felony offense, and is a sex offender on the registry as a result. So if there's any causation that would lead to Erica Patterson being a bad mom, Mr. Brooks has a direct role in that causation.
So he's not going to take too kindly to that because he was just called a sex offender in open court for everybody to hear, because when he and Erica Patterson first got together and she got pregnant, she was in fact a minor. And that story and that plot thickens at the end of the day as well. So stay tuned for the next chapter in this poor family's life that Darrell Brooks was a major part of.
And that's
Furthermore,
not to that,
I'm not
because
gonna-
that's a lie.
Let
Because
him
at the end of the
finish.
day,
Let
if
him
we
finish,
gonna open the door on
Mr.
that, no,
Brooks.
since he want to make a record and not be accurate, so let's be accurate all on the record since you think you know so much.
Once
So we
again,
can
Mr.
open the
Brooks
door
is
on,
being
we can open the door
loud,
on how old she told me she
disrespectful,
was when we met.
interrupting.
We can ask that
He
question
is
too then.
over the top.
We can open the door on how old she told me she was when we met. We can open the door on that. That's why it's statutory. I think it said seduction or something, but I mean, it's just.
Did
you know that?
Mr. Brooks, I'm ordering you to sit down and to let the
No,
state finish.
I'm not going to sit here and let somebody be inaccurate on the record and lie on the
Right.
record.
Under Illinois versus Allen, I've warned him repeatedly. He's being removed from.
Mr. Brooks, I'm ordering you to sit down. No, he's not going to sit down. Okay. Okay. And then she's going to kick him out of the courtroom, right?
The courtroom. And you know what? Let me dial that back. We're just going to take an early lunch, 1 hour. We'll be back. And unless he brings that letter, then he can show it is inadmissible. She will not be questioned. And under 906.11, I will declare the cross-examination closed. Thank you. We're in recess 1 hour.
Get your facts straight. So let's open the door on all of it again so we can get all of it on the record. Since you think you know so much. Did you know she said she was 18 when I met her? Did you know that?
Did you know she said she was 18 when I met her? Did you know that? And he's looking right at that prosecutor. You know it, even though it wasn't on camera. But once again, the judge kicked him out of the courtroom, but wait, not really. She didn't actually kick him out of the courtroom. She should have. She could have. She said, I'm ordering you to sit down. And he said, no, I've seen defendants be belligerent. I've seen defendants do things, but this is a whole new level for a judge that is just taking way too many hits from this guy, in my opinion. And then a little later, she kicks him out of the courtroom for real about an hour and a half later. And it's like deja vu. She's putting on the record why she's kicking him out of the courtroom. And she's kicking him out of the courtroom because, anybody want to guess? Yeah, subject matter jurisdiction. And it's not a lawful law. Is that a tactic agreement? That's why she has to kick him out of the courtroom later. Lisa is one of the ones that sent me the clip. A lot of people did. P-Hop, 7,000 watching. There's over 9,000 watching, which I think is our biggest Darrell Brooks live stream. That's fun. Hit that like button if you haven't already, please, all 9,000 of you, and subscribe. There's got to be some people that aren't subscribed now, just because there's more people than have ever watched these. Patty Hall. Hopefully it's okay I call you Patty. His name is Darrell, not Darrell. It isn't pronounced Darrell. Thank you, Patty. Yeah, Zena, I agree. It was a tough watch, no doubt. Diamis is making a live. All right. So after she kicks him out for the same exact reason, oh, there's the subscriber counter. That's fun. Am I going to be able to share the video still? I'm going to go back to the video. Okay, yeah, I'm going to go back to the video here. But John, throw that up when I'm answering questions, if you can, or if it's Bella, throw that up while I'm answering questions, please. All right. So she kicks him out of the courtroom, but she tries to let him back in, of course. And let's hear how that interaction goes. This is after the lunch break. And this is when he's in the other courtroom is some of his most disrespectful behavior of the entire time.
I've been advised he can hear and see. Mr. Brooks, we are on the record. I'll go through the topics one by one. You are in the other courtroom. You are invited back here. Would you like to come back here? Yes or no?
He's reading his Bible, by the way, in case anybody was wondering, acting like he can't hear
The
her.
audio is on. Would you like to come back to this courtroom, sir?
Oh, P.S., just so you know, and everybody can be aware, because I'm sure some people are going to get upset, the audio gets a little funky sometimes when he's in the other courtroom. And sometimes you can hear an echo from the judge, because I think we're also listening to his feed inside that courtroom.
So I'm finally unmuted.
You've been unmuted for a while, since I came back on. My understanding, sir, is you'd like to be in that other courtroom. Is that true?
So this would be a lesser included, Christy. That would be a lesser. They are charging him with intentional homicide, and I believe reckless homicide is a lesser included. And of course, he acts like, I couldn't hear you without it. Janelle thinks he himself proved intent. We're going to tell you what the poll says on intent in just a second.
To the courtroom. My understanding from a relay of information from the bailiffs is that you don't want to come back here.
I ain't saying that.
All right, are you ready to come back then?
Not if I'm just going to get held in contempt again.
I didn't hold you in contempt.
Then why am I even over here?
It's literally always a negotiation and argument. I would just say, that sounds like a no. Okay. And I would keep going. And guess what? He wouldn't do that again. He wouldn't make that argument again if the first time he said, well, not if you're going to hold me in contempt again. Okay, it sounds like a no. And then go back to the trial and give him another chance after this witness. But because she has this dialogue with him every time, in my opinion, he is pushing it more and more and more. And this is overstepping the bounds of what your constitutional rights are as a criminal defendant, your confrontation clause rights, your right to a defense. He is overstepping that. You do not have the right to disrupt the trial like the way that he's doing it.
So that I could make a ruling and make a record without an interruption, pursuant to my authority in Illinois versus Allen.
So did you make your record?
I did.
Am I ever going to get a chance to make the record without being interrupted?
Mr. Brooks, I'm asking you, the first question is, do you want to come back into this courtroom?
Not if you're going to hold me in contempt.
Sir, I need to continue with the trial. So if you don't answer yes or no, then I will presume you want to be in that courtroom, and you'll, by your conduct, waive your right to be in this courtroom.
By what conduct? I didn't consent
By
to being
failing
held in
to answer my question, sir. So I'll ask you again.
Are you going to hold me in contempt? I don't want to be held in contempt.
I will ask you again, sir. Would you like to come back to this courtroom?
I'm supposed to be in there anyway.
So twice now I've asked him. He has not answered a yes or no. Mr. Brooks, I'll ask you a third time. Would you like to come back into this courtroom?
Yes, if you're not going to hold me in contempt.
Given his yes, I will close the courtroom. He'll be brought over, and then we'll continue when he comes into this courtroom.
I just think that is not the way to handle it. And it's easy for me to do on the outside. Thank you, Stuck on Strings. It's easy for me to say here on the outside. So I want to be fair to this judge, but it's just not the right way to handle it. I think we have enough evidence at this point, weeks into this trial, that this is not the right way to handle it. Wow, we are climbing to 150 here together. Be part of the climb, people. Nell Bell, when will sentencing be held? I have no idea. I have no idea. All right. So then they get into this big argument about what else you're going to ask Ms. Patterson. And he says, I don't have that many more questions. I'm going to ask her about the police report. They object to it. They don't want people to be able to ask something over and over again, especially when you're in the situation where she's already been directed by the state. She's already been crossed by Darrell Brooks. And then she's already been asked more questions from Darrell Brooks. So to me, that is enough for one witness. And the judge feels the same way, which is why she's saying, I'm not going to let you continue unless you actually give me what you're going to ask her so that we can continue on with this direct examination. And he really has nothing. So that sets him off once again. When things don't go his way, that sets him off. So this is all happening right in the middle of Erica Patterson's testimony. And the judge realizes he's just harassing her. He's just badgering her. There's no reason to let him continue. So the judge cuts it off. I'm going to put the video back up there now. Let me see here. We got 434. But it's yet another argument here.
This is the first statement.
Is that the officer you just said?
Yes.
What about that report do you want to question this witness about?
The report is not in order, so again, as I stated before, I would have to read it.
Mr. Brooks, I trust that you're prepared. These are your witnesses. So what about that report do you want to question Ms. Patterson on?
Your Honor, I just stated 3 times.
Little Susie, a lot of people have said this.
I would have to read a little bit of this to form the questions.
under my authority, under 906.11, then, and given that this witness was initially called by the state, there was a full and fair opportunity for cross-examination by Mr. Brooks at that time, and they had ample time this morning to question her. I will declare that his questioning of her to be closed. I will bring the witness out on the witness stand and then we'll bring the jury out, and then I will simply ask the state if there are any questions, and then we'll move on from there.
Just so I understand what you mean by closed.
I'm not allowing you to ask her any additional questions, given your full and fair opportunity that you had previously when she was called by the state, and given the opportunity you had this morning and your failure to identify for this court any probative and relevant information that she would testify to about what's in that report.
How do I, first of all, the report isn't even in order. So I would have to essentially read at least some of it to even ask
Mr. Brooks, this is your witness. I expect that you will be prepared and you will not cause delay by any lack thereof. So I'm bringing the witness out, the jury will come out, and you will not have another opportunity to ask any additional questions unless the state asks questions on cross-examination.
So what is we bringing the witness out for?
I have to do that in front of the jury.
Man, I object to that ruling too. Can you give me a lawful law why?
Your objection is noted for the record. If you start interrupting me when the jury comes out or make any commentary, you will be removed to the other courtroom, and that's.
So I'm being held in contempt again?
No, it's not contempt.
All right, before he blows up, interesting here. Lindsay Lou says, unpopular opinion, I think it's unfair. He's not allowed to have standby counsel. And Taylor Flock says, FYI, public defenders are statutorily prohibited to act as standby counsel in Wisconsin. You'd have to retain your own attorney. I did not know that rule in standby counsel, but I know they did talk about it, and the judge said no. So he knew by waiving his counsel, he wasn't going to have standby counsel. So this is something that he knew. All due respect, Missy.
Contempt, sir. It's a finding under Illinois versus Allen. It's a warning that you will forfeit your
So
right
I might
to
as
be
well
present.
just
No
stay
such
over there.
contempt finding.
I might as well have just stayed over there then if I was
Mr.
going to be held in
Brooks,
contempt.
that decision is for you and you alone to make, and it is based on your conduct. If you're going
Just
to
take me over
continue,
here. Just take me over here because I'm not going to get held in contempt for nothing.
I have not held you in contempt.
You did.
You're
You're attempting to hold me in contempt. That's what that is.
No, that's not contempt.
So it's a civil or criminal.
Has anybody had somebody do this to them and say, oh, then just take me over there then? And they're doing the thing that, like, if they say they want to do it, then you're not going to do it, and like playing games. We've all seen this before. This is not a new tactic in arguments. And Cat Yarb, I agree. It's frustrating that the judge is allowing this type of childish behavior to go on. Like, send him over there then. He asked to, on the record, he said, send me over there. I would have stopped him right there and been like, then go, because you want to be over there.
Why am I being held in contempt?
I'm going to keep you in here because
that's the whole reason I didn't want to
call
come.
the next witness, and I'm going to need to bring you over in any event.
That's the whole reason why I didn't want to come over here, because you was going to find a reason to hold me in contempt.
Well, I'm finding a reason, and it's not contempt, but I find a reason to remove you based upon your disruptive.
Well, then
outbursts
remove me if
that
that's
you're-
what you want to do. Remove me.
I don't want to do it, sir. I want
Obviously
you
you
in this
do.
courtroom.
Obviously you do. You brought it up before we can even get to.
All right, Mr. Brooks has forfeited his right to be present in this courtroom for the remainder of this witness. Even
So
though it will be
did I
short,
actually forfeit that right?
you have forfeited your right to be present.
And how did I forfeit that right, Your Honor?
Right. We're going off the record so that he can be removed to the other courtroom, and he can call his next witness after we complete with Ms. Patterson and giving the state an opportunity from the neighboring courtroom. And once you can promise to this court that you will abide by the rules of decorum and civility, and if you're willing to conduct yourself consistently within that, then I will allow you to come back over.
She never actually makes him promise it. Do you notice that? She says, if you promise, then you can come back. I agree, Missy Misdemeanor. She doesn't even look 18 now. And wait till you hear how wild that is at the end of the video. But why even say that? Why say you have to promise this and then not even make him promise it? I agree, Pam. Why argue with this guy? It really doesn't make any sense to me. Oh, man, we're definitely hitting 150 tonight. You guys are awesome. This is crazy. We're going to hit 10,000 people in here soon. Whoa. Linda, we answered this a couple times, so I don't want to go over it too many times, but he just basically tells his story from the stand, gets cross-examined, and then can talk again on redirect. For a more in-depth version of that, listen a little bit earlier. Yes, Dana, I think they're going to make sure he never gets out. All right, the next section here is... All right. Yeah. This is when, she just literally lets him act like a baby again, then gives him another chance and another chance and another chance. And he just takes off the headphones in the middle of the judge talking to him. That's mind boggling, right? Let's use as many of those as we can. That is not a lawful law. That is not all due respect. It is mind boggling how he handles this situation and frankly gets away with it. I mean, as much as somebody who's going to be in prison for the rest of their life can get away with something, but it's wild. So immediately she kicks him out, and let's see how this is going to go for her. Jury's coming back in. They see him on the camera now.
All right, the jury is no longer in the courtroom.
There we go. Or they're going out, sorry. But
Mr.
they
Brooks,
saw
I
him there.
had the jury leave the courtroom because it appeared to me you wanted to perhaps either ask to come back into the courtroom.
She brought the jury in. He does something that makes her think he is going to come back and say sorry and thank you and whatever. Let me come back. So she kicks him back out. Again, I would let the trial run a little bit while he's over there so that he knows you will actually do it. And it's totally legal, and you're not stepping on his constitutional rights by doing that, especially when he can see and hear everything in there. He can question witnesses. He can do everything he needs to do in there, especially now that he's already confronted all of his accusers and the victims in the case, because the state's case is done. This is his case in chief. He can ask his questions from over there as far as I'm concerned.
Room or make another record of something. Do you want to come back into this courtroom as you call your next witness? You're not muted. You're unmuted.
I'm not sure what you mean, ND.
Am I being held in contempt yet again?
The record will reflect that pursuant to Illinois versus Allen, Mr. Brooks was not held in contempt, although that is one of the possible ways for a trial judge to handle a defendant who is stubbornly defiant, disruptive, and contemptuous. That is not the only way in which a judge can address a defendant that is being discourteous, disrespectful, and disruptive. So pursuant to the authority in Illinois versus Allen, I found that you forfeited your right to be present based upon your conduct. I'd also direct the parties to some persuasive authority from other jurisdictions that are more recent, including People versus Cone from the state of Colorado, 160 P. 3rd 366. It's a Colorado.
She's got some new sites here, which is good.
And then from the state of Washington, from their Supreme Court, State versus Davis, 461 P. 3rd 1204. That's from 2020. And I'd remind the parties of the district court decision that was later affirmed from Pennsylvania, U.S. versus Jennings, 855 F. Sup. 1427 from 1994. The finding was, sir, that you forfeited your right to be present based upon your conduct.
David, yes, they do. They can talk to people. They can get counsel on how to deal with difficult situations. Absolutely.
Okay, and all those case laws you just cited are pursuant to that.
Sir, I will ask you, would you like to come back into this courtroom as you continue with the calling of witnesses and your next witness?
So once again, she's putting the ball in his court. A. O'Connor, he's certainly going to be convicted of crimes. These will not be disputed. The sentencing will be more than his lifetime, regardless of what sticks. How will an appeal help in the future to his sentencing? Would this even be allowed? So his appeal wouldn't be to his sentence. His appeal would be to the conviction or something that happened in the trial, most likely. And last time we checked, there were, I think, almost 4,000 votes. 80+% said that the state has proven intent in first-degree murder. And about 20% or a little less than 20% said no. So most of you are feeling yes. And I got to be honest, as we've talked through a lot of these, through a lot of the different trials, you guys have been pretty spot on with how the jurors are feeling because, well, what do you know? You guys are potential jurors. So usually that's a pretty good indication. So the judge puts the ball back in his court. Let's see what he does with it.
I thought you was using Illinois versus Allen.
You are welcome to come back into this courtroom, sir.
So why was I removed in the first place then?
I've made my findings. The record will stand. I will ask you one last time. Would you like to come back into this courtroom as you call your next witness?
You're not going to hold me in contempt no more. Not going to do that.
Mr. Brooks has not answered.
Like, Judge, you got to promise me something for me to come back, not the other way around. That's what he's saying. You got to promise me something. She's saying you're going to promise me. He's saying, no, you're going to promise me.
My question directly. So based upon that, I'll advise him that if I will ask one more time and he fails to answer it with a yes or no, I will take that as a no, that he wants to stay in that courtroom.
You can't answer. You can't answer
Mr.
for it.
Brooks?
You can't do that. You can't do that.
Mr. Brooks, I'm advising you that I will. He's interrupting me once again.
Okay, you talk. You're the one talking right now, so don't do that.
I'm going to mute him because he's not being respectful and he's just spouting off. So he did not answer my question directly. He has not reclaimed his right to come back into the courtroom because number one, he has not requested it. Number two, he hasn't answered my question about whether he wants to come back in. And number three, he hasn't stated or demonstrated a willingness to conduct himself consistently with the decorum and respect inherent in the concepts of courts and judicial proceedings. I will give him one more opportunity so that it's abundantly clear on this record that I am honoring his right to be present, and I will unmute him. Sir, would you like to come back into this courtroom as you call your next witness?
Don't try to seem like you're trying to honor my rights now, but you have.
Okay, he is again not answering the question.
Don't try to seem like you're trying to honor my rights now. He knows what he's doing, and that's what I'm saying. When you have somebody like this, when the judge is responding like she is, it's almost playing into exactly what they want. He knows she's scared of stepping on his rights. He knows that, and he's going to lean into it.
question
don't try to
directly.
put on no- don't-
I'm going to mute him again. As I've noted before, this is a clear method now that Mr. Brooks is employing, that when I've done something that he disagrees with, that he just continues to argue
Absolutely,
with me,
Emery.
and does not answer questions directly. So based upon his continued disruptive behavior, the fact that he will not answer my questions directly, I'll find that he's continuing to forfeit his right to be present in this courtroom. Clearly, the audio and visual technology are working. He's been responding, although not appropriately. He is in that other courtroom. We can see him. He does have the headphones on, and I confirm that he can see and hear as well, based upon the court personnel that are in the other courtrooms. I'll make another finding that his appearance from the other courtroom is the functional equivalent of him being present in this courtroom. Mr. Brooks, before I unmute you, I am going to advise you, I will ask you to call your next witness. And if I don't get a direct response out of you, I may ask it again. And if you fail to give me a direct response, then you will forfeit your right to call any other witnesses. So I'm going to unmute you. Actually, I need to bring the jury back out. But before I do that, I will unmute you first and ask you which witness you intend to call, so we can at least have that person ready to go and outside the courtroom. Who will be your next witness?
I'm not calling no witness if I got to be in this other courtroom.
Would you like to come back?
That's fine. Then you're done, dude. Okay, you're done. That's what I would say. I'd say, okay, you're done. And I'd mute him. I'd bring the jury back in. I would send Ms. Patterson home. I think that's where we are. I'm kind of getting lost. I would send Ms. Patterson home and say, okay, thank you, Ms. Patterson. You're done. No more questions here. And then I'd say, okay, we're done. Mr. Brooks, you have no more witnesses, right? You're not calling anybody from there. Maybe you shouldn't go over there with how you're acting. But no, she plays right into it and continues to convince him. And I get it. She's trying to avoid a mistrial. But at some point, you've got to lay down the law. Dana Rose, just found your videos. Mad respect. I feel like we should raise funds for this judge to have a spa day. She needs a spa week, maybe a spa month, Dana. DB is extremely dangerous. And when she said that his stare was scaring her, I felt that deep in my bones. I hope she's safe. Yeah, I see a lot of other comments about that. We are definitely going to get to that. But thank you, Dana. And we're happy to have you. Glad you found us. Tell your friends if they're interested in this trial and stuff like it, of course.
Come back into this courtroom, sir.
Why was I ever removed? You never answered.
I've made a record of that, sir.
I have to answer everything, though. Everything you ask me, you expect me to answer. But then when I ask you questions, you never have to answer anything.
That's how it works, dude. She's not on trial. Nobody accused her of killing 6 people. She's a judge. She's at work right now. She doesn't have to answer your questions. I wish that's what she would say.
I just put on the record that 2 of your bailiffs just made gestures. When I'm looking at them off the reflection of the screen, they're making gestures behind my head that make me feel uncomfortable. I just brought that up on the record. You didn't even address that.
Mr. Brooks, I didn't address it because frankly, you keep interrupting me and then I have to deal with the interruptions and make a record regarding that. So I just saw the captain walk over. I will let security personnel, Captain Dussault, look into that. And if appropriate, he can bring that conduct to my attention. I'd also remind the defendant that at any time you can also ask to be brought over through the bailiffs who are in that courtroom. So to be abundantly fair to you, I will ask one more time, would you like to come back over to this courtroom?
I should have never been removed.
That's not answering my question, sir.
Gosh.
You haven't answered my question.
The court's not going to answer questions directed at the court by the defendant because they're not relevant or probative at this time, and they're a delay and disruptive tactic.
They're
Mr.
not a
Brooks,
delay and disruptive tactic. Is that a judicial determination that you're making?
I'm going to mute you because we're going off on the judicial determinations. Every decision I make, sir, is by definition a judicial determination.
Thank you. Thank you. How simple is that? Every decision she makes is a judicial determination because she's a judge making a determination. See how that works?
It is on the record. If there is a conviction, you can raise whatever issues you want on appeal if you are convicted. But we don't need to have this back and forth every time to further make the record when the record speaks for itself. You were given plenty of opportunities throughout this trial to make offers of proof, to state your legal reasoning for either an objection or for a question that's being asked or for a whole host of other things. But right now, you're not doing anything legally relevant. You're being disruptive. I would like you to be present. That is always what I want during this case. It certainly, I think, is important, but you can forfeit your right to be present by your conduct, which you have done repeatedly throughout this case. I will advise you that if you are in that courtroom, because I have put you there and you have not reclaimed
Probably
the right to be present by number one, asking and then expressing a willingness to conduct yourself consistently with decorum and respect inherent in the concepts of courts and judicial proceedings, you will remain over there. And it looks like he took his headphones off. So I would.
That's just the worst. That pisses me off. I can tell
Mr.
she's
Brooks,
getting
I'm
pissed
advising
too.
you that if you fail to
Just
call a
look at her.
witness, you will forfeit your right to present any additional witnesses. And I'm doing this outside the presence of the jury right now for a reason. I need to know from you right now, you are unmuted. Who is your next witness?
They all can hear him. They can all can hear the judge over there.
That was
What
very
you trying to say?
disrespectful, sir.
Yeah,
You
like
chose to
what?
take off your headphones. You
Yeah,
choose
because
to
I'm
read.
muted. I'm muted. So why am I gonna have my headphones on and I'm muted?
Well, I would think your headphones help you hear. The
They
muting
do.
is so that I don't have to hear the disruptions.
Okay, well then why should I need to hear?
So
what you
let
say?
me be clear, sir. And you
don't
are
gotta
not.
be clear nothing. I don't gotta listen to you.
I will ask you one last time.
It's
sir.
over right there. It's over for me. He said, I don't got to listen to you. And he sat down and picked up his book. Don't let him call a witness. Call it. Call it. MVD, they have something that it's the equivalent of that.
Who is your next witness?
First of all, she's talking to me.
Oh my gosh.
This.
We gotta keep doing this little childish stuff, dude.
I agree. I agree.
And I'm supposed to
Darrell.
follow every single rule, but nobody else got to do that.
The record should
Judicial misconduct.
reflect that Mr. Brooks
Repeatedly.
is spouting off, making
I think
unsubstantiated
the record can hear me. I think
allegations
they can hear me.
against this court,
Unless I'm
directly
muted.
attacking the integrity of this court and these proceedings, while yet
This court ain't got no
refusing
integrity.
to answer
This court don't have
simple
no
questions. Mr. Brooks, you
That's
are,
not my name. I told you I don't consent to being called that name.
sir, you are hereby advised this is the last time I will ask this question,
Don't talk
or
to me
you will
like that.
forfeit your right to present
Can't do that.
any
Show me what-
additional
show me
witnesses
where that's law.
because
Show
you
me
are
where
not
that's law.
cooperating with this process.
Show me that it's law. That's all I'm asking. Show me that it's lawful law.
Mr. Brooks,
How can I forfeit not being able to have a defense? Are you kidding me?
all I'm asking is that you conduct yourself with dignity, with decorum, and with respect. I will
Okay.
gladly bring you back into this courtroom so you can present your additional witnesses. But you need to ask me to come back into this courtroom.
With all due respect,
He's not going to ask you, dude. Come on. You know that.
I'm tired of having this back and forth with you every day. It's not my intention to come in here and have these interactions with you every day. It's not. Regardless to what you may think, regardless to how you may feel, that is not my intention. Okay? I simply do what I do because I do not have the understanding. So if I don't understand something, I'm
Okay. So he doesn't understand something, right? Just wait, because we're about 2 minutes away from him explaining the elements of Illinois versus, I don't even remember what the case is. Illinois v. Allen. He's going to explain the two elements that work how he wants them to work, leaving out the third element that she asks him what it is. Oh, we're hitting it very soon. She asked him what the third element is because she knows that it would be fair to say the third element is, you can put it back up, John, so we can actually see it hit 150. The third element is send him to the other courtroom. So he left that out when he was reciting these to her, when he's saying he doesn't have that understanding. But when it comes down to it, he actually does have that understanding. I think she does have full knowledge of the case in the state law. She absolutely does. I really think she's just trying to do what she thinks is best for this case. Hey, 150K. That's awesome. That's a lot of fun. Let's see how high we can get tonight. Maybe we can get to 151. That would be fun. And we'll have to figure out what giveaway we're going to do before this trial ends. And we will let you know. If you're a subscriber, you will have a chance to win something. Something fun. All right, let's get back to this. And let's hear how much he understands.
I want to ask a question. I apologize if it makes you feel that I'm intentionally trying to delay the proceeding. I'm intentionally trying to be disruptive. Because that's not the case. And I feel very, 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 very disrespected every time the record is made, making it seem like that's what I'm attempting to do. So of course it's gonna frustrate me. Of course it's gonna make me a little bit upset. And I just want you to understand that. It seems to me the way I'm interpreting what you're doing, which is it is your courtroom. That's not it. It's not a dispute. It's not up for debate. You control what's going on in there.
I'm glad he knows that. Doesn't seem like he knows that.
But the way I'm interpreting what you're doing is that I'm being held in contempt. That's how I'm interpreting. Because one of the three things that's cited in Illinois versus Allen, one of them is being gagged. I haven't been gagged. One of them is held in contempt.
What's the third, Mr. Brooks? What's the third?
The third is removed from the courtroom while the trial continues, right? That's the third, right?
And is
Do you see that? I mean, now he sounds like a lawyer. You know how many defense firms send me a motion and they cite a case and they only cite two of the elements because they're good for them, and they leave out the third element that actually proves our case? That's literally what he just did. He knows what he's doing. He is trying to make this as miserable as possible, and so far he has been very successful in making this very miserable. Yeah. Mrs. Rogers' neighborhood, I would not have handled it like this.
that's what's been done.
Or like this judge did.
Okay. So now, where does it say after that having me on a headset or being able to see and hear and all this and this, how is that not prejudicing my defense?
Sir, you can raise that issue on appeal.
Not
You can raise that issue
prejudicial.
on appeal if you are
This is why I say
convicted.
that. This is why I say that though, because I can't even see. The only thing I can see right now when I'm looking at the TV is you and the prosecution table. I can't see anything else.
I understand that, sir. I'm fully aware of that.
So I'm not fully aware of what's going on in the courtroom. Don't I deserve that right to be able to see and hear everything that's going on?
If you can conduct yourself consistently with the decorum and respect inherent in the concepts of courts and judicial proceedings, the answer then is yes. So I'm not going to have a debate with you about the law.
You literally just had a debate with him about the law. You just argued about Illinois v. Allen with him. I feel for this judge because it's miserable. And the reason, by the way, I started off by saying I don't like to disparage judges or lawyers in trials. I really don't. I give them every benefit of the doubt. And I'm saying it's easy for me to sit here and say what I would do, but it's actually her job. She's trying to protect the citizens of that county. She's trying to get a good verdict that actually holds up past appeal. And to me, I understand that. And I think that she's got to do the best that she can. People are too hard on the judge. I get that, Mel Mitch. I get that. But the reason for that is being a trial lawyer is incredibly difficult and stressful. And being a trial court judge is also very difficult and very stressful. So you have to give these people grace, like I talk all the time. And that's the reason why. This is a really hard and stressful job. It takes so much time, so much energy. You hold so much in your head. You hang on every word during a trial. So, as Jody said, bound and gag him. That's one of the things they can do. Rob thinks he's definitely going to testify. What's up, Rob? Every outburst is bigger than the last, and they'll continue to escalate as he approaches the end of trial. As we know already, too, he's not above just kind of lying. Does the judge have legal counsel or assistance on how to handle him as the judge sequestered? So judges go to judge school. So they have that. They also have other judges that are more senior, that maybe are retired judges, that they can ask, like, how would you deal with this difficult situation? So they definitely can seek counsel and things in situations like this for sure. All right. So after all this, we finally get to another witness. And it's interesting if you watch him start every one of these witnesses with, what do you do for a living? Oh, wait. He asked a question. Let me back up. What do you do for a living? Because he thinks that's like how lawyers start. And his second question is always, okay, directing your attention to November 21st. So it's kind of funny that like he thinks he's being a lawyer by asking what they do for a living when it has nothing to do with what he's asking him. It's not relevant at all. But a lot of lawyers do start out certain things like, what do you do for a living? Not with witnesses that were at the parade like he's doing. But it was just kind of a funny crutch, I thought. This witness couldn't really see the person who got out of the car. Dark hair, white or purple shirt, dark pants, 5'6" to 6 foot. That was about it. That, it was kind of this wide ranging description. It wasn't, a perfect description of him, anything like that. And then we get to the next witness, who was another bystander at the parade. Didn't see the driver. It seemed like there was nothing really important that he said, but on cross, they said the SUV tore off down the street. There was an interesting part of this one that, so he said shots fired. So the shots fired thing came out during this witness, and Brooks is definitely going to argue that he heard the shots firing, and that's why Brooks felt like he really had to get out of there because the shots were fired. I think if I'm trying to get into his mind and his arguments, that's probably what he's trying to do, is make an argument that it was dangerous and that's why he had to flee. And, he just ended up fleeing in the parade route. All right. He's going to get to coaching some witnesses here. And this is where we're going to get to the stare down with the judge, where she says she's scared, and we'll get into what implications that has. Oops, it's not on. I just realized. Sorry. Might be. You didn't miss anything. He just said, judging by these reports. Here we go.
How are some of these answers allowed to pass when they're coming straight from reports made by people on the stand? Very curious.
I don't understand your question. I'm not sure what you're asking me.
What I'm asking is, reading from the report that the people on the stand are giving, the report that they gave to law enforcement.
If you're asking me whether there's a mechanism in the rules of evidence and how to establish that before the jury, the answer to that is yes. If you're asking me how you do that, I'm not going to answer that.
I didn't ask how. I just, to be blunt, which I've been since the beginning of this trial, obviously, I see the whole strategy here by the prosecution. I see right through it.
Yeah, he thinks he's slick, right? You can see this smile and face that he makes just makes you cringe.
Don't have any cross-examination, mainly because you've already schooled the people getting on the stand on how to answer certain things.
Well, that is completely speculative on your part without
It's
any
obvious.
basis in law or fact.
It's obvious.
Sir, you could ask questions that establish that. You can ask them if they've met with anyone. You haven't done that. So for you to say that right now is without basis. If you want to,
It's clear.
if you are looking to elicit what they said in the report, there is a way under the rules of evidence based upon the way the witnesses have answered to clarify that requires you to call certain witnesses. I'm not going to give you any more legal advice further than that.
I don't think I have to
So
call any other witnesses.
if you're asking me to strike their testimony based on your
I didn't say
perceived,
anything
then that's
about that.
all right. Then I'm going to bring the jury back out and you're going to call your next witness. So I'm
So
not
is
hearing a request from you at this time. You said you wanted to raise a legal issue. What's the legal issue?
The legal issue is how is the state allowed to coach the
You're
people getting on
assuming
the
they
stand?
spoke to them and coached them.
It's obvious. I'm not stupid.
Well, I disagree with that, sir. Again, you could ask
All of a
questions.
sudden-
That was kind of funny. Remember that? She said, he's like, I'm not stupid. And she said, I disagree with that, sir. Now, I don't think that's what she meant. I think she was responding to his other statement. But I did think that I did laugh a little bit. I chuckled inside when she said, I disagree with that when he said, I'm not stupid. I don't know if any of you did or if any of you caught that.
Lay a foundation
all of a sudden, the
with
state
these
don't got,
witnesses.
all of a sudden, for the first time in trial, all of a sudden now they don't got no cross. That's clearly a rush to try to get through the case. Hurry up. We just gonna let these people go.
Well, this is
Nah,
argument.
Come on, man.
You're allowed to not cross, Mr. Brooks, and they're not crossing some of these witnesses because they are so good for them after you're direct. That's how it works. That's the reason you don't cross. And if the state does want to hurry through the case, and one of the ways they want to hurry through the case is not cross-examining your witness, that's good for you. That's where you get it, where he just he makes some coherent argument sometimes, and then you're like, you don't get it.
This is argument on your part, sir. It is pure commentary
I just
at
want
this
that on the
point.
record. I see through.
And your
Nice try,
see-through
but I see through.
has absolutely no basis in fact.
I know that's what's being done.
You
Come
could
on, man.
ask these questions. You could
Come on,
ask
man.
these
Got the right
witnesses
one.
certain questions, and you're
far from idiot.
They're your witnesses, sir. You believe.
So I'm gonna start asking every witness up here that they seem just to mysteriously now not have any cross for. Have they been coached to answer the way they answer?
Well,
Because
you can't
I
ask that, but you can ask them if they've met with anyone ahead of their
I find it
testimony
very
here
funny.
today,
I find
which
it
you've
very
done
funny.
with other witnesses.
I find it very funny that these are their reports, and now all of a sudden you can. Oh, I saw the person in the car. Oh, but
Mr. Brooks,
I
this
saw
is
the
an
breach or
attempt by
something.
you
Oh,
to
I don't
delay these
recall what
proceedings.
they had on.
Mr. Brooks,
You
there's
recall
no
saying
purpose
somebody
for you
reached or
saying this
something.
right
You don't
now.
know what they had on. I find that
All right,
very.
I'm having the jury brought out. I'm instructing you to
Come on,
avoid
man.
the commentary when the jury comes out, or you will
I didn't
forfeit your right to be
I didn't say
present.
nothing. You.
Pick up potential as to witness by the name of Abel Westcano. He has prior criminal history.
Thank you.
So as long as the jury's out, we should probably discuss that. I would like to provide the defendant and the court with.
So that had to be said. So it's the defendant.
Somebody put that in the chat. How he says the defendant. And she's like, sorry, I have to scream every time because you interrupt everybody. Let me take a second here. Say thank you to Ian, Runkle of the Bailey. I'm sure all of you are already subscribed and check out his channel. He and Rob are both in here to celebrate 150K hitting the milestone. Brentwood let me know they're both in here. I appreciate both of them being in here. That's awesome. So many cool creators on here are so supportive and so fun and smart to be around and see the stuff that they're making. He should be recording though, as he stated. So go check out Runkle of the Bailey and Law and Lumber. Thank you, Carrie, so much. I'm going to go rapid fire with these questions and comments after we finish the last couple clips. CMC, thanks for covering. Niners fan, how do you think CMC will play tomorrow? I think he'll get some touches. He's electric. I think he can make some big plays right away. Running back supposedly the easiest position to translate from one team to another, but now CMC is on CMC's team, right? All right, let's get back to it here. By the way, run the record back would not tell you how it was said. It would just read as defendant.
This is to benefit you so
No,
that
it's
you
not.
understand
Ain't none of
your
this to benefit me,
witness
so let's
has
be
a
clear about
prior
that.
record.
Your Honor, when I leave the table, I'm away from the courtroom and I have to elevate my voice. This is the
So she
alleged
got
record of
elevator voice just
ableist.
for that.
Stop talking.
Oh, man. Like, I don't know who y'all think y'all fooling. I'll set the value in return for value this document.
One more interruption and you're going to be removed to the next
That's
courtroom.
what you want to do anyway.
It's not what I want to do. Do not interrupt Attorney Opera.
So can
Your
you,
Honor,
so
I
can you
believe he
sleep?
has 7 prior criminal convictions.
He just interrupted her 2 more times after the judge said, if you interrupt her, I'm going to send you to the other courtroom. It's frustrating.
The OWI second from 1997. And
So
OWI
I don't know if you guys heard that. Let me back it up just a little bit so we can hear that. So listen for that boom when he pounds the table and then watch for the stare.
Set the value in return for value this document.
One more interruption and you're going to be removed to the next
That's
courtroom.
what you want to do anyway.
It's not what I want to do. Do not interrupt Attorney Opera.
So can
Your Honor,
so
I
can you
believe he
sleep?
has 7 prior criminal convictions. The OWI second from 1997, and OWI third from 1997, and OWI fourth from 2003, criminal trespass to dwelling from 2006.
All right, I need to take a break. This man right now is having a stare down with me. It's very
So this is the stare the judge is looking at. And yes, I agree with you in Ashes of Dreams. She probably just goes and screams at the end of the day. Check out that stare. So somebody asked, and I will find it. I'll get to it eventually, but I'm going to answer it right now. Can pounding the table and doing that stare, can that be a charge? So trying to intimidate a judge can absolutely be a charge. There can be assault. There can be threats. There can be intimidation tactics done by defendants that can end up being charges. I don't think this one will be, but I mean, this guy's like, he would not be in my courtroom ever again after this, ever again. And I think you have every absolute legal right to kick him out for good for the rest of this trial. But she doesn't.
very disrespectful. He pounded his fist. Frankly, it makes me scared. And we're taking a break.
And so the break is taken. Lascano, the guy with the 7 crimes, talked to law enforcement. He's the one that said 3 black suspects got out. So that's basically his best inconsistency, although he said, I don't really remember a lot of things. He's also not very credible. He identifies Brooks, but again, I don't think he was very credible for that. It was actually Brooks. He was a good inconsistency for Brooks to point out. Okay. So I can actually understand why he called Lascano to the stand, because he reported something that was inaccurate to law enforcement. But the next witness, who a lot of you have already mentioned, is the mom that Brooks decides to call himself, and I just don't get why. But let's listen to this testimony, which was the tearjerker testimony of the day. I was fighting it back listening to this, and I'm just thinking, you know what? You get what you ask for sometimes. And that's exactly what Brooks got by calling this witness.
Of Main Street, is that correct?
Yes.
Is that when you saw this vehicle we've been talking about?
Yes,
So you were standing in the crosswalk.
correct.
Do you remember a police officer being in that intersection?
I can't be too sure.
Was it clear to you that this was a parade route?
Yes, it was very clear.
Was it clear to you that traffic from White Rock should not have driven onto Main Street
Yes,
unless they were part of the parade?
yes.
Did it appear to you as though the vehicle we've been talking about was part of the parade?
No.
How many children do you have, Ms. Darrell?
Objection irrelevant.
Overruled. Man. 4 children.
Frankly, she held it together so well during direct and most of cross until that question. I didn't see this coming with her because she was pretty stoic throughout the entire testimony, but then you hear why.
All 4 of your kids were marching in the parade that day, weren't they?
Yes.
Objection leading.
Overruled. Sorry.
Your oldest daughter, Charlotte, she was 14 at the time.
Yes.
She was marching with the Extreme Dance Group as an alumni, wasn't she?
She was handing out candy.
Objection.
There was an objection. It's overruled.
I didn't even state why I was objecting, but
He objects a lot here because he realizes how bad this is getting for him.
we still need a 15.
Yes, please. You see on that map the 5 points intersection?
Yes.
When you were standing in the crosswalk at White Rock in Maine, could you see the 5 points intersection?
I could not.
You didn't see your kids get hit, did you?
I did not.
Objection, leading.
Sorry. Okay, I'm sorry.
Objection, hearsay.
You didn't.
I did not.
Did you see them later that night?
Objection, leading.
I was only able to see 2 of my children at night.
When did you see the other 2?
Days later, when I was able to leave Children's Hospital.
As their mother, you were directly involved in their medical care, the decisions that were made in that process in the days after the parade?
Objection, leading.
Yes, their father and I.
Charlotte suffered a chipped vertebrae from being struck, didn't she?
She did.
Objection,
Sorry.
leading.
They're allowed to lead. It's cross-examination. Could you imagine if you were trying to put together your own defense? Do you think you would have called this witness? Because I wouldn't have. I'll just tell you that. If he had a lawyer, they'd be like, we're not calling her. If the state doesn't call her, we're lucky.
She did.
Your daughter Alice, she was 10 at the time, wasn't she?
She was.
She suffered chipped front teeth, is that correct?
Yes.
And facial scarring,
Yes.
and road rash,
Yes.
and a broken fibula and tibia,
Yes.
and broken metatarsal bones.
Yes.
She was observed in a concussion protocol, is that correct?
She was.
Your daughter Vivian, she was marching with the extreme dance group too, wasn't she?
Yeah, she was.
How old was she in November of 21?
She just turned 7.
Vivian suffered a severe concussion, didn't she?
Objection, leading.
Yes.
And road rash,
Extreme road rash.
and a lung contusion,
Yes.
and facial scarring.
Yes.
And your 7-year-old daughter Vivian suffered a broken tailbone, didn't she?
She did.
Your son Grayson, he was 8 on November 21st, 2021, is that correct?
That is
Objection,
correct.
leading.
He was walking with the extreme dance group, handing out candy, is that right?
He was.
He went to the hospital after the parade, didn't he?
Yes.
He suffered a compound fracture in his femur, is that correct?
An open compound fracture.
Meaning the bone came through the skin?
Yes.
Objection, hearsay. I'll believe he's a doctor.
That's what a compound fracture means. I've had one. I know. They suck. And the bone does, in fact, come out of the skin. That's what makes them compound.
The witness may answer based upon personal knowledge.
Is that a yes?
Yes.
A police officer saved Grayson's life by placing a tourniquet on that open leg wound, is that correct?
Yes.
I don't have any other questions.
No redirect.
Potentially the best movies made all trial. No redirect. Yeah, last night. You're right. You're right. The next witness is the law enforcement officer, female law enforcement officer that was at the parade, heard the honking, hand gestures moving out of the way. That's what he's trying to get out of her, that he was trying to get people out of the way. But then she said something creepy, that he looked through her. He looked through her. Very, very creepy. And then they start talking about whether or not she was injured. And he's not picking up what she's putting down because she says yes. And he's like, oh, I've got another thing to impeach her on. Look, she's not telling the truth. But he doesn't get what she actually means, which, again, is bad for him, as most things are in this trial. And so let's listen to what she meant by the suffering that took place as a result of his actions. Yeah, I agree, Ladybug.
Were you injured the evening of the incident?
Yes.
You were injured?
Yes, I was.
Any reason why that's not reported?
Probably because I didn't tell anyone else.
If you were injured, why not tell anyone?
Because I haven't wanted to talk about the traumatic experience that I went through for
still reliving the weeks and days after the incident.
It doesn't make any sense. You talked to FBI agents a few days where you said you didn't, to be fair, you said you didn't know. You said it was that week, is what you said. The same week. You spoke with FBI agents. Reported no injury.
They didn't ask me about injuries.
Well, would it be fair to say that that kind of information would come up when talking to law enforcement, seeing as how you yourself work in law enforcement? It just seems odd, don't you think?
I do not. I was not physically injured.
Oh.
So he thinks he caught her in a lie.
But you didn't report this at any time whatsoever. Rounds.
Sustained. Already answered.
So did you?
She says, I didn't want to relive this traumatic event over and over again that I'm still reliving now. And then more under the breath comments, won't sit down, spouting off to the judge. The judge finally cuts him off. And we get to perhaps some of the most disrespectful comments I've ever heard spoken to a judge. And then we'll get to some shocking revelation made, in my opinion, at the end that I didn't know about. I don't know if a lot of you guys did, but let's first hear him go off once again before we end for the day.
Recall the details that they don't recall.
Yeah, that's what
Sustained is to the form of the question.
Seems very funny. Seems almost as if you're recalling what you want to recall and purposely not.
Objection, badgering the witness.
Yes, sustained. You do not have to answer that, and you are warned. You may not badger or argue with this witness. Next question.
Badger or argue. What do you mean?
Next question.
What do you mean?
Don't intimidate the witness, what I mean.
I'm not saying it.
Okay, so let's pause for a second here. So she's right. He was badgering the witness. She was right to cut him off. But she should not have said in front of the jury, intimidate the witness. Do not intimidate the witness. You're trying to intimidate the witness. That is, in fact, also a crime. And listen, the guy sucks. I probably shouldn't have said that. That could come back to bite me. But the guy is rough. He's a tough hang. I would never want to be stuck in a courtroom with him for weeks. So I get all of that. But I don't really think he was trying to intimidate this witness. I think what he's trying to say is, you're trying to help the prosecution, not trying to help me. You remember when it's convenient for you, not when it's good for me. And that's an argument a lot of lawyers make and a lot of defendants make. But for the judge to say that he was intimidating the witness, to me, is pretty rough in front of the jury, and probably the biggest error I think the judge has made in this entire case. Because it's not as if he was saying, you better say what I want you to say. He was saying, oh, real nice. So you remember it when they're asking, but not when I'm asking. Stuff like that, which those are proper arguments. So that is tough. Like that's not a good look from the judge. But don't worry, he explodes now, so we get to see that. Christine M., yeah, I guess it's possible he just doesn't know what they're going to say. It's never too late for the Bible, Robin. Life in prison, that's one of the rehabilitation things we can hope for.
Badgering the witness by eye rolling, by pursing your lips, by making facial movements regarding her answers is badgering the witness.
Are you kidding me?
Under 906.11, please ask your next question.
You can't be serious right now. Intimidating the witness. What have I done to intimidate the witness?
The last question was badgering, which is a form. Can you?
Mr.
Brooks, I've made my ruling under 906.11. Please ask a question or I will stop the question.
How did I intimidate?
Under 906.11, sub 1, sub A, sub B, and sub C, ask your next question, or the questioning of this witness will end.
How are you even a judge?
All right, you may step down, ma'am. Thank you.
How are you even a judge? Come on, man. This must be all about necessity to trust, right? That you want to be the beneficiary of?
I'm going to give the jury their closing instruction. We are done with testimony for today. Please do not begin your deliberations and discussion of the case until all the evidence is presented. And I have instructed you on the law. Do not discuss this case among yourselves or with anyone else until your final deliberations in the jury room. This order is not limited to face-to-face conversations. It also extends.
So there are a few more arguments at the end of the day that I find interesting. The first one was about Don Woods and whether or not they need to subpoena her because, you don't need to subpoena a witness if you can just tell them to show up, and they do show up. And let's hear what he says.
And obviously, she can appear here voluntarily if Mr. Brooks wants to arrange that. I don't believe a subpoena is necessary. We had subpoenaed her, and she was under state subpoena. So I know that at least some point she had notice, but our position would be, Your Honor, that we will not be responsible in any fashion for producing Ms. Woods. Mr. Brooks talks to her on a daily basis. If he wants her here, he can produce her on Monday.
Yeah, they ain't got to worry about that.
So I just wanted to know, because I know subpoena form was filled out. So
If I wanted to be here, she's going to be here.
I agree with
So
the
just
state
know
that
that.
she could certainly appear.
There ain't even got to be no arrangement. All I got to say is come. She going to come. That simple.
He's even disrespectful about that. Like his mom, who is talking to him, if he needs her to come testify, she'll come testify. Yeah, I feel bad for his mom. Gosh, it's so sad.
Mr. Brooks, do you intend to call her as a witness? Because I'm directing you to have her
We
here
said
at
all
9
that- we said
a.m.
all that at the beginning, man. Like, I don't even want to be in here that much longer. Just do what you got to do so I can get up out of here. I'm tired of being in the courtroom that has no integrity whatsoever. How can you even call yourself a
Mr. Brooks,
judge?
I need to make a record of
I need to make a record too.
You don't
When
need
am I
to-
going to get the chance to do that?
All right, I need to make a record. He's being removed to the other courtroom. He is yelling at me. He's not going to let me make a statement or make the record that I need to make.
I'm finna
He
do
hasn't
it
sat
anyway, so
down
we'll do it
for
now.
the
You can
better
hold
part
me
of
in
2
contempt all
hours.
you want. You can hold me in contempt all you want.
I'm not
All
holding
you
you
gotta
in
do is say
contempt.
if it's criminal or civil, so I can hit you
Okay,
with you.
I need to clear the courtroom because I do need to
I'm gonna give
make.
you what you know is coming.
I need him to go to the
If
other
it's civil,
courtroom because I do need to put some
if
things on
it's
the
civil,
record. The record should
Where's the
reflect
contract between you and I?
that Mr. Brooks
If it's
is yelling
criminal,
at me.
what is the crime?
He is.
Who makes the claim? And what
He
is
is. I will make the record when we get back. I will step off, but Mr. Brooks, you're being
It ain't
taken to the
no
next
Mr.
courtroom.
Brooks. Don't try to address me
Thank
like
you.
that, like we cool. You don't have no integrity. How can you even call yourself a judge? Making tacit agreements, being biased, judicial misconduct, trying to steal somebody's.
Don't call me Mr. Brooks like we're cool like that. It's like, dude, she does not think you're cool. She does not think you guys are friends at all. She is not interested in being cool with you or being your friends. It's like the guys that go to strip clubs and thinks the strippers really like them. It's not what she's doing by trying to be cordial with you in court. All right, so here was some of before we get to the Q&A, the last portion I want to play here is frankly shocking to me, something I did not know about Erica Patterson and Darrell Brooks and their child. And then Darrell Brooks, we find out some truth about that letter with the pictures and who's actually been reaching out to who and how that relationship has worked since November 21st. You won't be too surprised at what you hear, is my guess.
To the Waukesha County Sheriff's Department as they were memorialized in supplement number 55 under an incident report number of W21087731. The second of those was a one-paragraph summary of the statement provided by Jason Hayes to the City of Waukesha Police Department, memorialized in supplement number 28 under incident report number 21047-493. These were, again, documents that were provided to Mr. Brooks in the discovery process, but we sought to be helpful in his presentation of evidence here at the trial today. The second issue that we'd like to make a record about relates to the testimony of Erica Patterson. So for the record, I think it's important to note that the two photographs the defendant attempted to show that witness and presumably put into evidence depicted what I believe to be the defendant and Ms. Patterson's 15-year-old daughter, as well as their new grandchild, the daughter's child, who was born around May 1st of 2022.
So they have a grandchild. Their 15-year-old daughter has a child. And it's some kind of pattern because Erica Patterson and Darrell Brooks, he got her pregnant when she was a minor, and now their minor child just had a child. And that's like the Darrell Brooks family here that it's sad. This affects a lot of people's lives in a lot of different ways. And that's the sad reality of what a person like this can really become and affect. So I think that's really sad. And it's also sad for Darrell Brooks's mom, who probably sees that as, these are her family members. And then all that's broken because of him is really sad. But let's continue to hear what their relationship is really like now between Erica Patterson and Darrell Brooks.
I think that there was ample grounds for the court to end Ms. Patterson's testimony when it did, but for just in case that becomes an issue going forward, I'll make an offer of proof that Ms. Patterson, if asked about those pictures, would have testified that she did not provide them to Mr. Brooks. She provided them to a person named Michelle, who I believe is a mutual friend, who in turn provided them to Dawn Woods, the defendant's mother, long day, that was the person who provided them to Mr. Brooks. If she were forced to answer questions about this supposed letter that Mr. Brooks was claiming to exist, she would have testified that she has not written a letter to Mr. Brooks since he came into our jail on November 22nd. She didn't write one on November 21st either. At any point between his being taken into custody and today, it's my understanding that he has tried to call her from the Waukesha County Jail on 37 occasions. She has never accepted a single one of those phone calls. And finally, during the early lunch break, I was informed by the bailiff staff that the defendant was twice offered to go to his cell to retrieve that letter that he talked about. He declined both times.
Thank you. I appreciate the record being made. I will now.
So he's called her 37 times. She's not accepting calls. She's not writing him letters. So it obviously wasn't true that she sent him those pictures. What did you really expect? Right? I mean, what did you really expect? The bailiffs kept telling him, we can go to your cell and get that letter. And he didn't want to do it. So that's kind of where we're at with him. And, you know, that's just kind of par for the course for everything we've heard about him throughout the entirety of this trial. Okay. 12,000 people are in the chat right now. That's wild. Hit the like button and subscribe if you haven't already, because now we're going to get to the Q&A portion. And this is the longest Darrell Brooks video we've done. We've got about 10 to 15 minutes here to answer as many questions as we can, and then we're going to call it a night for this Saturday night special. So thank you to everyone that joined. Biggest Darrell Brooks video or group that we've had to date. JCar, are appeals based off specific laws or just anything? They're based off specific laws and specific things that happened during the trial that would be reversible error. Joe Gottman, if a judge says the defendant scares them in front of the jury, is that grounds for a mistrial? How do you do in golf? It is not grounds for what's going on here. Okay. It's not grounds for a mistrial, but she shouldn't talk about it in front of the jury, frankly. I can't remember if the jury was actually in the courtroom when that happened. I played decent, not my best, not my worst. MVD, having known the domestic victims, wouldn't maintaining contact be ineffective? Yes. Kate Manda, is there anything DB could do to actually be banned from the remainder of the trial? I mean, your guess is as good as mine. I feel like he's done it. T-Bird, when she saw that she could waive his rights to call any more witnesses, would that have been reason for appeal or mistrial? No, not based on how he was acting, in my opinion. You could have at least made him sit over there for a little while. I probably wouldn't have cut it off for the whole trial, but at least make him think you might do it. Alyssa Hendry, there was a change in the judge. Later in the day, she was not firm. Could she have gotten counsel from a colleague? Another judge came to my mind. Absolutely possible. Paisley Dreams, the judge saying she was afraid and then leaving the bench for 25 minutes was shocking to me. It's okay to feel like that, but why say it? She's making a record. She's really trying to make a record, as much information as possible. Jordan the drummer, could you explain what rush to judgment means and whether DB ever uses it correctly? Sorry if you've covered this before. It's not a real thing. Rush to judgment just means like she's not making a good judicial determination or whatever he wants to say, but it's not an actual real thing people use in appeals. It's a sovereign citizen thing. Katie, so during sentencing, she's allowed to give him a scolding. How does that work? I've never seen sentencing before. So we did Jussie Smollett's, which you should watch that one. We did Ronnie O'Neal's. We've done some sentencing breakdowns on here, and the judges give a piece of their mind. She can say, you had no remorse, you were rude, you were angry, you badgered witnesses, you put victims through another part of abuse after what you've already done to them. She's allowed to go off on him during sentencing if, in fact, he is convicted. Megan Sukowski, when a witness identifies DB as the driver and he only objects with this dumb name objection, isn't he entering a tacit or tacit agreement that he is the driver? That's just not his name. Unwitting confession. You'd think so. Kevin, does he gain anything from discrediting his own witnesses? No, but that's the point, is none of these witnesses are his witnesses because they're not really good for him. This tracker's kind of annoying me up there. Please subscribe, even though the tracker's not up, but I don't want to leave it up there this whole time. It just feels weird watching numbers click. Sean Cousins, the detective didn't tell me anything. I'm sorry, didn't tell me everything. Is that a valid claim of misconduct by police? No. MVD, how reserved do you think the prosecution has been? What angles would you have taken that haven't been taken. I think they're doing great, actually. I think the prosecution's doing great. They're not being too aggressive, but they are not being passive, in my opinion. I don't think they're being too reserved or passive. Gen B, when he acts, I have felt like a couple times that I would have wanted to be like, or what? That's what I wanted. I kind of wanted the dude prosecutor to be like, or what? He's like, oh, we're going to put the facts on the record then. Do you know how old she told me when she was 18? I would be like, I don't care how old she told you she was. I don't care. Like, I feel like I would just want to, this guy would really frustrate me. When he acts up in court, why can't they just shock him a few times? Yeah. Matt Bond, can hitting the table and staring down the judge be a charge? Potentially, but I highly doubt it will. Daniel Ortiz Lopez, when he was admonished for badgering a witness and said to the judge, you call yourself a judge, I wanted to throw my keyboard. I agree. It's like, no, sir, she doesn't call herself a judge. She actually is a judge. She went to law school. She practiced law. She became a judge. You don't just get to call yourself a judge. Chris Lafreniere, what happens if he decides to obtain counsel? Is he allowed to do that mid-trial? If so, would that trigger a new trial? No, it wouldn't trigger a new trial. Somebody said he could pay for standby counsel in Wisconsin under some weird rules. I'm not really sure. The judge is not allowing him to flip-flop back and forth. Unseen King, I didn't see the prosecution's witness testimony, but based on his witness testimony, I think intent was proven. Multiple statements saying sped up. That's how bad he's doing. Unseen King didn't even watch the prosecution's case in chief, but just based on Darrell Brooks' case in chief, he thinks he's guilty of intentional homicide. Last night, if he testifies for himself, will he have to call himself by the name on the stand? That'd be interesting. Judge, like, state and spell your name. I'm sure he would just refuse to. Carla Miller, I was thinking about this on his opening statement. I honestly think he got emotional, not for what he did or for himself, but because he wasn't connecting with the jury and felt panicked. According to people in the courtroom, the jury wasn't buying it. Anna Marie B, in my opinion, she is allowing him to bully her. When he stared her down, she said she was afraid, then took a break. He is playing off her with intimidation, or she is very smart and knows that putting that on the record is going to go a long way for the appeal. Shauna, why is she letting him get away with so much? I'm originally from Wisconsin. It's so embarrassing. New sub, appreciate you. Awesome, Shauna. Thank you so much. She's just trying to protect this record from an appeal. Simple as that. She does not want to give him an out. If he gets convicted, she wants it to stick. Law RN, it's obvious she has never dealt with a passive-aggressive manipulator. Go back to pretrial hearings. Judge had such control, so decisive. See, that's what I'm saying. I think it really has to do with protecting this trial from appeal. Carla Miller, because what does he have to lose when she threatens him to be removed or held in contempt? Best case scenario, she ends his case. I agree, but he doesn't want to be removed to that courtroom where he can be muted. That's the point. Taught 9-year-olds for 3 years, 3 strikes and timeout. She gives him more than 3. What can the judge actually do to him? It's annoying, but she's actually hurting the trial. Put him in the other courtroom and mute him. It's simple as that. He can scream and he can throw his headphones down if he wants, but he can partake in the trial from that other courtroom. That's what I would do. P-Hop, why does he keep saying she is holding him in contempt? Would that stop the trial? Yes. She wants him to hold him in contempt, make findings, throw him in jail, because then he can't be sitting there watching the trial. He just wants to delay or have a chance to get a new trial. Melanie, lawful law. You keep using that word. I do not think it means what you think it means. Little Princess Bride for you, right? Mara Chandler, important is when it is brought up that at one point he couldn't see out of his windshield due to a body on it. He had to put his head out the window. Yeah, I remember he had his head out the window. I couldn't remember if it was because the windshield smashed or, I mean, that's just horrible. How can the judge handle him harsher, David Barry? She can frankly gag and bind him, which I wouldn't do if I was a judge, but I would send him to the other courtroom and mute him. If DB testifies, how will he be asked questions from the defense? IU Liab, he would just sit on the stand, give a narrative, explain his side of the story. Then he would be cross-examined by the state. Becky, can you please explain intent a little bit? I don't think he got up that day planning to drive through the parade. At what point does it become intentional? That's something for the jury to decide. And I think the state's going to argue that as he continued to drive at high speeds through this parade, he intended or knew that he was going to kill all these people and intended to continue driving. So the intent usually has to be the intent to kill. But you can get there different ways. And I think they could say he intended to continue driving, which was the mechanism of this killing. And he continued to intend to do that even after multiple deaths. That's, I think, their best chance to get there personally. But I think at the very least, this is a reckless homicide. Judy Grass, can the judge revoke his right to defend? We've got another poll here. Is this judge too lenient? 81% say yes, 19% say no. So it's been fun to have the polls going this video as well. No, she's not going to revoke his ability to defend himself based on competence. Gabrielle, abuse is like cuts. We think we'd never fall into one. This judge has managed 12 days of his abuse. It has to be affecting her physically and mentally. I'm sure she's not having a good time. Jill Lazaroff, why does he always say asking or telling and hurries to say, I'm asking you, whatever they are talking about. I love your channel. Thank you so much. He is saying, are you asking or telling purely like your son or daughter or somebody may say to you in a disrespectful tone, like, if you ask me to do it, I'll do it. But if you tell me to do it, I'm going to be defiant. That's basically what he's doing. Mark Quinn, great channel. If the jury did the unthinkable and acquitted Brooks, could this judge declare herself a 13 juror and call for a new trial? No, not without something crazy happen. It would be double jeopardy. Crazy Cat Queen, were there to be a mistrial, would the same judge have to preside? If not, it seems like a great opportunity to get a hard arse Marine type judge assigned. It would depend on if they got transferred, but she would probably preside again. Dari, can the bailiff or officer behind him make him sit down and behave? If the judge tells them to, you better believe they would. Rob, again, more generosity, man. You're killing me here. Cheers to 150K. Congratulations, my friend, and thank you. Your LYK faithful were amazing in the chat last night. Onward to 200K. Yes, we're climbing towards 200K. We might even hit 151,000 tonight. Let me add it back. I'll add it back up here. We can tick it as I go through the last few questions here. But thank you, Rob, and I'm glad everybody went and hit the Friday night show for Rob since I couldn't be here, so that was good. You still got your fix of a lawyer breaking it down. Dark Shadow, 150K subs. Congratulations. Love your channel, by the way. If he testifies, I heard they can't cross-examine him. Is that true? No. The judge has even told him, you will be opening yourself up to cross-examination. Robert, shouldn't a bailiff get in his face when he attacks the judge like he does? I think he's shackled to the table, plus has shock things on his legs, so he's not going to get anywhere if he tries to charge the judge. But in normal cases, the bailiff would be up if he wasn't attached to the table. Marcy C. Peter, there's people saying the witness have to be careful because he's in the gang, the Bloods. Can he have them hurt by the gang? I love you and what you do for all of us. Thank you so much. Thank you, Marcy. I don't know. I mean, I don't know if he's got hits out on people or something, but I think the witnesses are being honest. They're not being rude to him. What's his name? Kirby. Mr. Kirby was not at all afraid of him. Amanda E. What about the leg shackles? If he testifies, they will shackle him to the witness stand outside the presence of the jury. The jury will leave. He'll be on the witness stand. The jury will come back in. They've done things like that a few times. Unseen King. Silly question. If the judges are elected, are they actually required to have a law license? I'm trying to remember. There are some appointed judges that you're not actually required to have a law license. I'm not sure if it was in Wisconsin, you do have to have a law license, but there have been Supreme Court justices that don't have law license that weren't actually lawyers. But the vast majority of judges are lawyers. Missy Misdemeanor. Peter, did you catch in his interrogation when the detective talked about the Bible verse? DB correctly nailed the exact book, chapter, and verse. My jaw dropped. I did not see that, but I would love to see it. Send me that clip. If you guys want to send me clips like you've heard me talking about other people, go follow us on Instagram and Twitter at Tragos Law. We talk a lot about this stuff on there in short, sweet hits. Jay Melendez, can victims sue the car insurance for their injuries? Yeah, but my guess is he doesn't have anywhere near enough policy to cover all the damages he created. David Smith, even without seeing all of this, won't the jury know that something is going very wrong just based on how long they're out of the courtroom? Absolutely. Absolutely. Great pickup by you. DW, why does he always ask her if he's being held in contempt? Is that to delay the trial? Yes. Love the channel. Thanks. Yeah, you guys pick up on this stuff, okay? You guys pick up on this just like the jurors pick up on it. And that's exactly why he's doing it, D. And if you know it and I know it, you better believe the judge knows it. Terry D, favorite YouTube channel I've ever joined. Well, you guys are my favorite chatters ever. Thank you so much, Stacy Walpole, for the congratulations. Steph Morris, can they just keep DB in the other courtroom? Yes, and I wish they would. Caitlin, I don't know that it's fair to feel sorry for his mom. He is a product of his mom and upbringing, which is sad and sadly more common than you might think. I don't know his mom. I feel bad for everybody in his life, if I got to be honest with you. From what I've seen, it would be a tough road. Benjamin Martin, will he call himself to the stand, and what name will he use? A lot of people asking if I think he'll take the stand. I really don't know. I could see it going either way. Rob said absolutely. He's a narcissist. People are saying he's going to want to hear himself talk, but he also has used the system and tried to work the system as much as possible. And I could see him trying to testify through these questions, trying to testify through his closing argument. But then again, if his goal is to delay taking the stand, he could try to sit on the stand for a full day. Mark Lane, do you think he argues because the judge and prosecutors are women? Some people have said that. I don't know. I think this guy would argue with anybody. Des Asientes. What are the chances of a fellow sovereign citizen getting through the jury selection and sitting on this case? I wonder if they asked that during jury selection, if anybody was a sovereign citizen. If so, it's going to be a hung jury, would be my guess. Chief Inspector Clouseau. Actually, I don't know. I mean, even a sovereign citizen will probably convict this guy. Chief Inspector Clouseau. Any chance of jury nullification? I highly, highly doubt it. Emily Hollenbeck. If he were to testify, who will ask him questions? Nobody will ask him questions on direct. Most likely, he will just get up on the stand and give a narrative, and whoever wants to on cross, probably the DA, if I had to guess. Lex Lux. Feel like I'm cheating, but you're my favorite lawyer now. Well, thank you, Lex Lux. And there can be polygamy in favorite lawyer YouTubers. Don't worry about it. Mark G. Who determines if he can file an appeal? He will be able to file an appeal. Drew Dole. How well do you have to know the law to craft an effective appeal? Does DB possess that knowledge? No, it's even harder than trying a case would be crafting an appeal on your own, but he'll get appointed counsel for that. And they almost always, even if they try the case on their own pro se, they almost always get an attorney for the appellate process and the sentencing process. I think Ronnie O'Neill did that as well. Got a lawyer for the sentencing process. Rashenda Reynosa. But if he takes the stand, he can't say I'm a third-party intervener on behalf of the defendant because they have to say a name, correct? They don't have to say a name. I mean, the judge can say, state and spell your name, and he could say, I'm a third-party intervener, blah, 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 blah. I don't know. She hasn't forced him to do a lot of things I would have told you they have to do. Like, I know what I have to do when I'm in court, and he doesn't have to do any of it. Jack, her fault. Her fault. She allowed pro pert. If he was forced to decide pro se or public defender, he'd have a lawyer. He said, I told you what I was going to do. Call his mom as a witness and ask her what she named her son. Yeah, Francine, that would be interesting, I'm sure. Jenna, do you think the state will cross him if he takes a stand? Absolutely. ADA Zach W. is crushing it. Long career runway ahead. I agree. I think he's done a great job. A great job. And we're climbing here towards 151K. I don't think we're going to hit it by the end of the night, but we hit the big number, which was really fun, guys. John Patton. I still thought the idea of transferred intent from the argument he had with his ex-girlfriend would be a good avenue for proving intent. The jury could get there a bunch of different ways. Stacy, 11K in the chat. Wow, growing so fast and well-deserved. You guys are just too nice. Jody Van Zwal, Sue Opper with the stress ball was all of us. Absolutely. She seems like a fierce woman and a fierce lawyer, and she is probably so annoyed at this guy right now. Don D. Spid 2404. Is there anything the prosecution can do to tame DB during his rants? Mute him. The prosecution, no, there's nothing really they can do. Pam, his mom went on TV and defended him. I know people have sent me the interview. I haven't watched it yet, though. We're going to break it down together eventually, probably after the trial. Kelly McLaurin. Did you see when he said, I'm not a person, I am a human being? Yes. Yeah, we did a video right after he did that, which was just wild. Why wouldn't the prosecution bring up his racist social media post now deleted during the trial? It's pretty prejudicial. They don't want to create an issue for appeal. They've got enough. I wouldn't do that if I was them either. Following since the Beverly Hills Bar Association during DVH. Gerald, that's awesome. That's awesome. That was really fun. And I met a few lawyers I'd never met before. Bruce called me afterwards. We talked for a little bit. Really good dude. So that was awesome. Let me run through a few of the new members here. Denise Clark has joined, as well as Ro Mama and EMCN. So that's always fun. Ozzy Rando, what chance does he have of getting an appeal granted? Slim to none. Less than 1%, I would say. Illinois Observer, does he have to answer under cross? Yes, he can't plead the fifth. He does have to answer under cross-examination because you open yourself up to that when you actually testify. Thank you, Michael Schinkel and Melinda Arroyo and Melanie Johnson and Nadia Ray for those super stickers. This is the longest video I may have ever done, and I am spent. We got to so many questions. We got so many new subs. It was so much fun to do this on a Saturday night. My wife is out of town, so I didn't miss any wifey time, so nobody's got to feel bad about that, right? Only 200 more thumbs up to get to 6K. So the 11,000 of you that are still in the chat right now, hit that like button on your way out of this video and come back Monday because the fireworks are not over. The judge told us the schedule. We're going to finish witnesses Monday, Don Woods and the defendant himself may testify. We may or may not stream that live. If you guys want to, let me know. Then we're going to have closing arguments. She's got 100 pages of jury instructions to read. So a lot left in this trial. I don't think we're going to finish before maybe Wednesday of next week at the earliest. So keep coming back. Every night we'll be reacting, breaking it down together. This is the spot to talk Darrell Brooks. We've done it together this far. Keep telling your friends and bringing them in because this is fun. Thank you guys so much for joining me. If I didn't get to your question, I'm sorry. I'll get to it next time.